You're watching 13 WMAZ Law Call, sponsored by Macon law firm Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes. Tonight, we're going to talk about a very important subject. I hope it has not entered into your world, but perhaps it has, and that's DUI and an alcohol-related accident. Ouch, those can be quite serious, but we have with us a master attorney who can answer some of those questions for us. So help me welcome from Reynolds, Horn, and Servant, Mr. Carl Reynolds. How are you, sir?
I'm great, Morgan. How are you doing?
It's always good to see you. I'm doing just fine.
Well,
now,
good.
Listen, I know tonight you have a very special guest, so why don't you take a moment to introduce them? And then I have a question for you.
Okay, great. I will introduce him. He is a very good friend of mine, an old friend. And I might add, I would say the preeminent attorney in Georgia for DUI. If he is the go-to guy for anybody who is facing the prospect of a driving under the influence charge. He not only is a go-to guy, but he's also the author of the book, the Georgia DUI Trial Practice Manual. And I'll show you the book. He gives seminars, teaches other attorneys about DUI, and keeps up with the law, and is always there to answer my questions. I don't do DUI work, although I have in the very, very long past. But I would like to introduce my friend Bubba Head. Bubba, welcome to the show.
Well, thank you, Carl. It's good to be here in Macon again, and appreciate that introduction. After 44 years, I'm not done as long as you have, but it's been quite a journey.
Well, welcome, Bubba. It's good to have you here with us tonight to answer some of these questions. But my first question is actually directed at Carl, because Carl, I want to know, have you ever tried a DUI case?
Actually, I have. I've tried very many DUI cases, but they were so far in the distant past, and Bubba can weigh in on this. When I first started doing a trial practice, I did all kinds of criminal cases, divorce cases, damage suits, contract issues, landlord line disputes, anything you could go to court with, I've tried. But back in the day when I did DUI defense, there was an element in the state's requirement that said they had to prove actual impairment. In other words, if they stopped someone for a suspected DUI, if it came to trial, they had to actually show that that person was impaired, that their eyes were red, that their speech was slurred, they were unsteady on their feet, they were weaving in and out of the lane. These were elements of impairment. Later on, long after my last DUI defense case, it became a matter of the ratio of your alcohol to blood in your system. And the state really doesn't have to show if you're impaired or not. I believe, and Bubba can enlighten us on this, but I think if it's a 0.08 blood alcohol ratio, you are by law under the influence. Now, what do you do then, Bubba, if you're stopped? You're really not drunk, you're not impaired, but you're over the 0.08. Where do you stand, and how do you do what you do?
Well, that's a good question, Carl, and there's so many factors in these cases. First question we ask people, do you have any prior record? Because if you have a prior record, the prosecutor doubles down and is not really interested in talking about a reduction. We have to fight for those if we're going to get it. But if you have taken the test and you're over the 0.08 limit, that's the adult driver limit. But if you're a commercial truck driver in a commercial vehicle, the limit's 0.04. And if you're under 21, it's 0.02, which is a half a beer. So if you're over the legal limit, then we have to find ways to win, usually looking for errors made by the police officer in giving what's called the implied consent notice.
Okay. That kind of gets us to the stop, the initial stop, doesn't it? And what you should or shouldn't do, and also depending on whether you actually know you are under the influence or you know that you're not under the influence. In either of those events, give us kind of a ballpark of what a person should do if they're stopped. And in one instance, they know they've had too much to drink. Okay. In the second instance, I've only had 2 beers. Classic answer. What do you advise people to do prospectively?
Well, what happens is the officer, after you're arrested, they're going to ask you some questions, and you should only give your name and address. That's all you have to tell them. Be polite and cooperate and do what they ask you to do. If they ask you to step out of the vehicle, don't resist that, because that's a lawful order. But when it comes down to them asking you to take a test, you're already in handcuffs. And you should say, "Would you have a right to an attorney? If so, I'd like to call an attorney." They will tell you no. And so you have to make a decision. And my advice to people is that you say, well, if I can't talk to an attorney, I'm going to go ahead and say yes, so that my license is not suspended for a full year, but I'm going to want my own independent test.
Okay. And now that's if you've already, as you say, been arrested.
You have to be arrested for them to read implied consent to you. And implied consent is just a notice that tells you they're going to be asking you for a type of test. If you refuse this test, your license will be suspended for a minimum period of 1 year. And so most people, when they hear that, they're going to take the test rather than risk being suspended.
Okay, going back to the other instance, let's say you've had a drink or you've had a couple of beers, but it's over a 3-hour period of time, and you're relatively sure you are not going to be over 0.08, and you're stopped, and they ask you if you've been drinking. What should a driver say to the police officer? You're still sitting in the car, let's say.
Well, same thing. If they come up to the window, they're trained to smell what's there. They're going to know you're lying if you say you haven't been drinking. If you haven't been drinking, they're going to know you're lying to them because they can smell it. So my advice is that you go ahead and remain silent except for your name and address. And if they get you out of the car and try to do field tests, decline those. Don't answer any questions. Don't walk around unless they tell you to step here or step there. And then when they do cuff you, they've arrested you with no probable cause to do so. And
Okay.
so many times we can get that case dismissed. But then if they cuff you, they're going to read you the implied consent notice. And that's when they're telling you that they've made an arrest. And if you don't take the test, you can be suspended for a year.
Well, that's why, and that's exactly why we shouldn't drink and drive. But we're going to talk about more of this topic because it's such an interesting topic. And we're going to come back and get to some email questions about people who've done just that. I'm Morgan Dukes, and you're watching Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, and tonight we're talking about DUIs and alcohol-related accidents, because if you drink too much and get behind the wheel of the car, it's a good possibility you just might be in an accident. And with us tonight, I have attorneys Carl Reynolds and Mr. Bubba Head, and both of them are very well versed in answering your questions. So let's get to some of your questions tonight. We have an email from Stephen, and this is pretty serious. Stephen says, if I throw a party at my house and one of my guests gets drunk and gets into a wreck going home, could I face criminal charges? Ooh, okay. Who wants to tackle that one first? Because that sounds
Well,
pretty
I think the
serious.
simple answer to that is no, probably not. But there are occasions where if a host serves somebody knowingly that they know is drunk and can reasonably expect them to drive, and that person leaves the house and causes an accident and an injury to somebody else, yes, they may be liable as well as the person driving the car. That comes under the general heading of dram shop cases in Georgia. It's a pretty strict requirement, though, that if it's a bar or a restaurant, the person has to be pretty visibly and clearly intoxicated, and the restaurant or bar serves them while they are visibly intoxicated. And there's another requirement in Georgia that the barkeep or the owner operator of the restaurant have some reasonable suspicion that that person is going to operate a vehicle. So yes, the supplier of the alcohol could be liable civilly, not criminally. And of course, the thing you do in that situation is you take somebody's keys away from them and say, we're not going to let you leave our house if you're drunk, and you can stay here, you can call Uber, or you can do whatever you want to do.
Mhm.
In a restaurant setting or a bar setting, it's the same thing. I mean, you just don't serve somebody like that. But there's no criminal responsibility on the part of a host. You want to weigh in on that, Bubba?
I'm just going to say the one thing that's happened a lot in my area, because I was in Athens for many years up till 1990 and then moved to Atlanta, is these teen parties. Sometimes when the parents sponsor a teen party and there's drinking going on, if you turn loose teenagers that are under 21 and you've been the one to supply the alcohol, you're on the hook for that.
Oh,
Yeah, and the advice to that is don't do it. Don't allow underage people to have a party, because they may do it without the parents' knowledge. In that case, the parent's not responsible for it. But if you supply alcohol to underage people, they go out and do mischief or do somebody hurt, then the parents may well be responsible for it on a civil basis.
well, let me throw this little caveat in there. Is the military exempt from these type of parties if somebody in the military gets drunk and decides to go out driving?
Goodness, no. They're
I-
responsible just like anybody else.
Okay, all
And
right.
the drunk driver is, of course, the ultimate cause of the accident. But
Mhm.
and you know, adults are pretty much responsible for their own conduct. The
Okay.
dram shop is it's used oftentimes when, I know there was we're not supposed to mention specific restaurants one time, but there have been several cases with a particular restaurant that served a particular drink, and it was a lethal concoction of alcohol. And a couple of those would put anybody under the table. And we've had several cases that were against those particular restaurants for serving people who they knew or should have known were drunk and were likely to drive.
Okay. All right. Well, we do have another interesting question, and this one comes from Ben. And I'm sure anybody who's been pulled over while intoxicated probably feels this way. He wants to know, can a police officer charge me with drunk driving even if he doesn't see me driving the car?
Good question.
Yes. So, Bubba, how would you answer that one?
Well, the police are trained to look for circumstantial evidence. For example, you're on the side of the road, your car's off, the key's in the ignition, and you're slumped over the wheel, and they finally wake you up. And as soon as they smell the alcohol, they know you've been drinking. And you think, well, I'm not driving, I'm over here on the side of the road. Well, unbeknownst to them, many times the officer will go up and feel the hood if it's a cold night, if the hood's still warm, or if there's been a witness that's called it in that saw him pull over, they can take circumstantial evidence and put a case together. There's one case from 1981 where the man had a small accident, single car. He was about a mile away walking to a service station. Police officers saw the car and realized that he would have not walked in one direction because there's nothing ahead. He drove back in that direction, found him. He admitted that it was his car, and they arrested him for DUI, and he appealed, but the case, they won the case, and he was convicted. And that was 1981 case out of the Athens area.
Yeah, there are other instances. What we usually get is this: somebody has pulled their car over, or they're in the parking area of a restaurant or an establishment, and they go to sleep and they're behind the wheel, and they are, in fact, intoxicated. If they're behind the wheel of the car, even though they're asleep and not driving, the theory is they're in control of the vehicle. So they can still be charged with DUI if they're sitting there doing nothing. And so the advice would be, if you're in that situation, you're going to do that, get out from behind the wheel, get in the back seat of the car, go to sleep, and then you're not in that situation.
In fact, I've got one more step. I told one of my regular clients, if she had this happen and she stopped, to not have the key in the car. So she had gotten out of the car and hidden the key. And when the police came on the cul-de-sac, because somebody called it in, they couldn't find a key. And even though she had DUIs, I got the case dropped because they could not find the key and they couldn't prove when she got there.
I've heard of that before, where somebody would get out of the car and just toss the key out into the woods somewhere. And I guess that's their way of getting out of the case. So
not something we would advise doing, though. I mean, I think the better advice is get in the back seat and go to sleep.
I like that too. I like that advice too. Attorneys Carl Reynolds and Bubba Head are with us tonight. We're talking about DUI. Oh gosh, alcohol-related accidents. I pray that doesn't come your way. And if you do, we have two great attorneys that can help you out. Listen, we're going to take a quick break, but we'll be back with more questions and answers right here on Law Call. If you would like to have further conversation with our attorneys tonight, well, you can reach out to William Bubba Head. You can find him in Sandy Springs, Georgia. Just give him a call at 404-567-5515, or you can reach out to him on the web at www.bubbahead.com. If you have questions for Mr. Carl Reynolds, you can reach him at Reynolds, Horn, and Servant right here in Macon at 478-405-0300, or online at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds, Horn, and Savant on Facebook. All right, gentlemen, we are back and we're talking about DUI and alcohol-related accidents. And when you're in one, it's a bad situation, but we have more questions, more email questions. And this one comes to us from Margaret. Margaret's question is, my son is on prescription medication for depression and anxiety. Recently, he was pulled over because the officer said he was swerving in the road. He was given a warning, but could he have been arrested? And how should we handle this type of situation in the future? So this comes from Margaret. What should she tell her son or advise her son to do?
Okay, well, I will defer to Bubba on that. Bubba, the swerving or the bumping into the line is always their probable cause for stopping when they're just out fishing for DUIs. But please go ahead and answer Margaret's question.
Well, the law says that you can't be under the influence of anything, even prescribed drugs. But if you've taken the prescription dose, you are given an exemption if you're within the prescribed limits. But sometimes people take too much medication for various reasons. If the person had been arrested and was tested and a blood was drawn for that type of test, because you can't get that from a breath test, that person may have been able to get the case reduced. But just by talking, instead of doing what I suggest, which is give name and address only, don't start talking about medications. Because again, he wouldn't have smelled of alcohol, and they're simply asking questions because they have no idea that he might be on some medication. But the person touching the line is not uncommon. I drove down here today and I saw about 300. So basically on a impaired driving case based upon drugs, they have to be able to prove that you were impaired by whatever it was, medication, prescribed, marijuana, any other type of drug. But again, they were not going to be able to prove it if he was within the therapeutic dose of what he's supposed to take.
Now, did I hear you correctly? You say that you shouldn't volunteer the information if you've taken a particular drug? You shouldn't mention that at all?
A lot of times officers just ask it. They have no basis for even asking the question. There's no smell of it. They don't see anything. They're just on a basically a treasure hunt, see if you're going to give them any information. Name and address is all you need to give them.
Morgan, the reality is that most people who are in jail are in there because of what they have said themselves. What Bubba is saying is make no admissions, period.
Okay. I like that. And I like that. I'll keep my mouth closed and I will advise everybody else to do the same. Our next question comes to us from Barbara. And her question is, I was recently injured in a car wreck with a drunk driver. He was arrested at the scene and I've since learned that he is unemployed and has no insurance. While I'd be happy to see him go to jail, that won't help pay for my car or my medical bills. Is there anything that Barbara can do? Is there anything?
That always brings us back to the same old subject, which is what is your uninsured motorist insurance? Because that will by contract cover that drunken driver and will pay to you what you would otherwise be entitled to recover from the drunken driver. As to the car, you might need to look to see if you've got collision insurance, or you could have a certain amount of property damage covered under the policy also. But we always ask people to go and look at their policies and see if they have uninsured motorist insurance, and if so, what are the limits of that insurance?
And as far as that, it's exactly what I would have said. Carl covered that perfectly. If they don't have a job and they're not paying for the damage, you can go to court when their case comes up for whatever the traffic ticket is that they were charged with. Make sure the judge knows that you have not received compensation for the car and the damage, or even personal injury if you have it. And the judge will require that person to either pay you before they can get a license, or they'll have a payment plan in which they pay that off over time to be able to get their license back at a future date. So you do need to make sure you go to court and let the court know that you've not been compensated. And that way the sword of Damocles is over their head, since they can't drive till they get you paid or get you on a contract with monthly payments.
So before we wrap up tonight, Bubba, you are a DUI attorney. That is your area of specialty. Is there a charge for a consultation if someone is watching tonight and they might want to get in contact with you?
Nope, free consultation on any criminal case of any type. And that's what we tell people. Call us, at least find out what your answers are. It costs you nothing.
Okay. And Carl, how about at Reynolds, Horn, and Savannah?
Same here. We're glad to talk to anybody about anything.
All right.
And, one call is free, certainly.
All right. Well, gentlemen, I thank you so much for being with us tonight. It has been very, very informative. Mr. Bubba Head, Carl Reynolds, two great attorneys. DUI was our topic tonight. We encourage you to make sure you tune in next week, and we'll get you some more answers. Until then, I'm Morgan Duke saying for all of us here at LawCall, good night, everybody.
Good night.
Good night.